Hi everyone, Scott Stork with Polaris Law Group, estate planning and elder law attorney. So I'm here today to talk to you about how to deal with retirement accounts in your estate planning. So what's a retirement account? We have clients come in, you probably have them. Clients come in with retirement accounts, and a lot of times it may be the biggest piece of their estate planning or of their financial portfolio. So it may be that they have 401ks through work. They have IRAs through their financial institution. They may have 403bs. They may have other types of retirement planning vehicles. But all of these things are retirement accounts. So they all have different rules, but they all have the same potential issues when it comes to planning. So retirement accounts are things where we can put money into them. A lot of times while we're working, we'll add money to that account. There are all sorts of limits associated with those as to how much we can put in a given year. But the whole point is at some point in time, then we're able to draw income off of that account. And if the money has gone in tax-free at the beginning, then when we take distributions at a certain age, that is charged as income for income tax purposes to us. If we have paid the income tax in advance by doing Roth IRAs or something like that, then those assets come out, that income comes out tax-free when we take it. The whole point is that there's different types of retirement accounts with different rules. When we do a regular retirement account, like let's say a 401k, and that comes out tax-free at the beginning, then how we take those distributions is dependent on a number of factors. But once we reach a certain age, and that's changing with something called the Secure Act, then those distributions come out with something called required minimum distributions. There's a minimum amount each year that you're required to take, and it's based on a life expectancy table. And as we take them out, then that draws down that account. Now, for people who are estate planning, one of the big things to know is those accounts need to stay in your name. So if we have clients who create trusts, that trust cannot be the new owner of a retirement account. We may name the trust an owner of a bank account or an investment account or a house or things like that, but we never want to change ownership of the retirement account for all sorts of reasons. There's tax reasons, there are penalties, there's all sorts of things that we would not want to do that for. Instead, we may want to use beneficiary designations on those retirement accounts. Now, why all of this is important is that there was a law that, or a Supreme Court case that came through about 7 years ago now, and what it said is an inherited IRA. So that is an IRA that if I have it and I pass away and it's left to my kids, they take it as an inherited IRA. So a lot of you may have those. What this case said is that inherited IRAs no longer have creditor protection, meaning if I get sued in a car accident or something like that, that retirement account that I have inherited is not protected. Whereas if I'm the owner right now of my retirement account and I get into a car accident, there are some protections from that lawsuit, but those are now lost when we leave it to our kids, especially as an inherited IRA. If we leave it to our spouse can do what's called a spousal rollover, and there are still some of those protections attached. So the big issue is when we leave these IRAs to our children. So we have to be very intentional about how we do so. For instance, you may have named beneficiaries through your financial institution, through your employer, something like that, and let's say you've named your kids as those beneficiaries. They now inherit those as inherited IRAs, but as I just said, they've lost creditor protection. So we've lost those ways to protect it if something happens to them. So we may want to replace those protections with something like a trust. So remember, I just told you that the trust can't own that, except if we name the trust potentially as a beneficiary of your retirement accounts, then your kids' retirement accounts go to them with some protective envelope around it that replaces that loss protection that we lost in that Supreme Court case a few years ago. So if we name the trust, and it's a protective trust, as the beneficiary, and the kids inherit it, then they can get some of those protections back, which is a very great thing for them. Now, there's a few issues with naming trusts as the beneficiary of retirement accounts typically. So the Secure Act, which has been passed a couple of years ago, basically says instead of giving what's called a life expectancy distribution for inherited IRAs, now those have to come out typically in 10 years. Leaving it to a trust, unless it's properly done so, means that the trust has to pay out in 5 years, not 10 years. And that can be a problem because there can be some tax consequences to that. A properly drafted trust, though, by an estate planning attorney who knows how to deal with these issues, actually can leave it in the trust with those protections, and it can get the same distribution rules as if the kids inherited them on their own. So instead of 5 years for that trust, a properly drafted trust can still get 10 years as the distribution period. It takes away those tax consequences, and it gives protection for those. So it can be very important, and it can be a great thing to still use trusts when we're dealing with retirement accounts. Now, doing this type of planning is not for every attorney. A lot of financial institutions and advisors are a little confused about how this works. So you need to make sure that if you've got retirement accounts and you want to leave them properly, that you work with an estate planning attorney who knows how to deal with these. It can be well worth the time and effort to do this to protect what you're leaving to your kids. And if you've got really good size retirement accounts, it can be even more important if you've got just a couple of beneficiaries and they're going to inherit a bunch from these retirement accounts. Leaving those protections around it can be well worthwhile. So you want to make sure that whoever you talk to do your estate planning knows how to deal with this. So one of the things that we do a lot is work with these type of accounts. We know how to plan for them. We know how to protect them. We know the pitfalls and the landmines that are out there with them. So if you'd like to talk to us about it, we'd be happy to set up a consultation with you. You can call our office at 636-757-3850. You can visit our website at polarisplans.com. Everybody's situation is unique. We will tell you the best way to deal with those retirement accounts and with all the rest of your assets when we're doing estate planning. So again, if you have any questions, please let us know. Thanks for taking the time to watch today.